Hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Good morning, everyone. You may be seated. The first case on for oral argument is 451, People v. Slaughter. Good morning, Counselor.
Morning, Your Honors. May it please the Court. Christine Cook on behalf of Mr. Slaughter. Your Honors, the use of CSAAS testimony in this state is approved, but with a significant restriction, and that restriction was referred to and argued strenuously as one of the reasons that CSAAS testimony is admissible. In this case, the expert testified several times.
Counselor, we recognize that there's a number of questioning that was, for lack of a better word, out of bounds, and it was objected to. But it appears on at least the second objection, ultimately, it was sustained and a curative instruction was given. And that seems to set it apart from the, was it Rue's case?
Your Honor, it doesn't, because number one, it wasn't the second objection, it was the third objection. There was an objection and the court overruled it, and so the prosecutor went on and asked the next question, and the testimony went further into grooming.
But ultimately, though, he sustained and gave a curative instruction, and defense counsel never asked to have it stricken from the record, correct?
There was not a curative instruction at the time of the objections, Your Honor. The only
He ultimately gave a curative instruction.
I disagree that it was a curative instruction.
Okay.
He gave the judge gave the instruction that is given at the end
Okay,
of this testimony
fair enough.
in every case. And that is the protection that there should be, that the testimony shouldn't come in, period, regarding because for at least two of the objections, the jury heard that testimony and was not told not to consider those answers and to consider that testimony. Your Honor, unless the court has other questions regarding that issue, I did want to discuss the issue of severance in this case, because the good cause for severance was established by a number of factors. The difference in the quality of evidence between the two complainants, the bias that occurs in sexual abuse cases, and that was recognized by the court in the Shapiro case. Most significant here, though, was the severe risk that the jury would convict Mr. Slaughter based upon propensity evidence to commit this type of crime. And this danger came to fruition in this case by the denial of severance. The prosecution's argument in opening and summation was for the jurors not to consider the complainant separately and individually, but to consider their evidence as proof that the other one's testimony was true. And went in great depth in the summation and argued that point, inviting them to consider that testimony together and as one complainant as proof of the other.
Thank you, Counselor.
Thank you.
Morning, Counselor.
Good morning, Your Honor. Brad Osa for the people. May it please the court. I submit that the court's, maybe it wasn't a curative instruction, but it's certainly a limiting instruction at the end of the expert's testimony. I submit that that was the appropriate instruction and certainly sufficient.
Yeah, I misspoke. It was limited.
And I'd also note just that the testimony that first drew an objection was certainly wasn't an intentional act by the people to try to elicit improper testimony. The expert was talking about the secrecy aspect, which I think is the first element And I think it may be sometimes a little bit difficult to parse talking just about victim behavior versus perpetrator behavior, but certainly I think the curative instruction solved the problem that the questionable testimony created. Briefly on the severance issue, I would actually submit the opposite of my opponent. I think a review of the people's summation would reflect that she actually encouraged the jury to consider each victim separately, and that the jury could find each of them individually credible.
I mean, the crux of their argument is that the strength of one of the victims here was a testimony is much stronger than the other one. And because one is more believable in the cases, the proof is stronger against one, that there's a possibility that then the other one must be telling the truth. Because the attorney, I have to admit, did a nice job on cross-examination. There's a number of inconsistencies that were pointed out.
Right, and I would obviously acknowledge that the victims were, I mean, they didn't offer identical testimony. They were certainly unique in both the facts and the way in which they testified. But that alone doesn't suggest that severance should have been granted. There's plenty of cases that have charges of I'll call it a sensitive nature like this, where two different charges or two different incidents can be tried together. And I don't think there was any sort of breach of longstanding precedent here. And certainly CPL 200.20 permits it. Unless there's any other questions, people.
Thank you. 452, Byler v. Byler. Morning, Counselor.
Good morning, Your Honors. Caitlin Connolly for the appellant Melinda Byler. Your Honors, the primary issue here is family court's finding of extraordinary circumstances. My client loves her children very much and requests that the court review this determination of the lower court. To start, Your Honors, it's submitted that family court erroneously relied on the 5-year separation between the mother and her children as a factor relevant to its determination because the mother was trying to regain custody during this time period. As this court held in matter of Cote v. Brown, the period of separation during which the parent tries to regain custody lawfully is entitled to little, if any, consideration with respect to the extraordinary circumstances.
So how many petitions did the mother file trying to regain access?
Well, Your Honor, according to the court, about 85, I
It
believe.
seems somewhat excessive, doesn't it?
Your Honor, all I can say is that my client feels very strongly about her children and loves her children.
But she is the one who surrendered the children in the first place to the aunt, isn't she?
Well, Your Honor, I would refer to this court's holding in Michael G.B. v. Angela L.B., which I cite to in the brief. And in that case, this court held that the fact that the parent agreed that a non-parent should have physical custody of the child or place the child in the custody of a non-parent is not sufficient by
Now,
itself.
we do want to encourage the parent who says she can't raise the child to do that. But the fact that she and her husband said they couldn't care for the children and gave them up in, what was it, August of 2015, that certainly is a factor.
I would say, Your Honor, I would argue that that shows responsibility on behalf of my client. She was sick at the time, so I would argue that's a protective factor.
But you keep you just said, you know, that factor alone is not enough. That wasn't the only factor. That was the basis of the court's decision. There were a number of factors that combined led to the court's finding of extraordinary circumstances.
Correct, Your Honor, and I would argue that there's a big problem here with the aunt's credibility. The court's finding rested on the aunt's testimony largely, and I would argue that it was not sufficient to sustain her burden.
Weren't there texts from the mother where she was going to steal the children or had a gun or would burn down the aunt's house?
Your Honor, our position is that it was never established that those texts actually came from my client or that she maintained the website.
Right, well, your client admitted that she went to the backyard and the front yard and was yelling things at the aunt. Your client admitted that she believes that she's actually the aunt. They were switched at birth. And this isn't her sister, this is her husband's sister. She admits all this. She admits that she controlled a website, that she set up a website, Jamestown Historical, something like that, that was posting information about the aunt and making statements. She admits that she created that website. She admits that she has mental health issues. She was in jail at the time. I mean, come on, if this isn't extraordinary, then I don't think we would ever find extraordinary circumstances.
Your Honor, I'd just like to say that my client admitted that she set up the website initially, but she also stated and testified she did not control the
Yeah,
website.
she said the person she gave it to is deceased now. and
Yes, she
therefore-
did not control the website.
But once again, though, you understand that, I guess was pointed out by my colleagues here, all three of them, is that we look at the totality of it. Maybe one may be shaky, one may not have been there, but taking it all together. And I think we'll look at whether or not all the factors that the court considered, whether or not that rise to the level of extraordinary circumstances.
Thank you, Your Honor. We're grateful for your review of the lower court's determination.
Thank you, counsel. 454 Vandy v. Soup Corporation. Morning, counsel.
Morning, Your Honor. Ryan Finn Law Offices for the appellants, plaintiffs. This is a class action case. This is our second time before this
Yeah, we're
court.
familiar with this. Some of us were on the prior case.
Yeah, so the issues here, we have the fringe benefit issue still at the center of the litigation. Is our contention, Andrew Vandy, the plaintiff, for example, he works a 40-hour work week. He's entitled to $20 an hour.
Counsel, we're familiar with the case. I guess one of the questions we'll start out with,
Sure.
maybe to deal with, is we've rendered a decision on this case, found that there was a question of fact. It went back, and then there were stipulated facts that were stipulation. There was a stipulation entered in both parties. How has that changed at all, that the facts, that what was done was any different than what we had before, which we denied summary judgment on?
We limited the issues, Your Honor.
But the issues you limited were also issues that were in the prior motion for summary judgment, wasn't it?
It was some of the issues. There was other issues as well. There was, at the time, we had, in our amended complaint, we had alleged different out of scope,
And you got rid of those?
I'm sorry?
And some of those you took out?
Yes. correct.
You limited. What I'm saying is if we're looking at 10 issues, and this court finds a question of fact, and then it comes back and it gets reduced to 3 issues of the 10, and with no further discovery, so to speak, how does it change our prior decision?
Well, I mean, frankly, during the prior decision, I would have thought this was an issue of law as well, and I would have said that this pooled trust issue raises a directed verdict for us.
Yeah, but we held otherwise. We said there was a question of fact, and it seems to me the proof before us now is no different than it was when we had the case in 2018. It seems to me that there's still an open question as to whether the defendant paid the plaintiffs the supplemental fringe benefits.
I don't think there is an open question any longer, because at the time they had alleged that they had made all these different trust payments. It wasn't clear exactly the defense they were going to allege. Here, we now, during discovery, limited very discreetly. They put every dime towards the supplemental benefits into this trust. The trust is a pooled trust. They followed this annualization regulation for the first deposit they put into the trust, because they recognize that 50% of the benefits go to non-prevailing wage work.
No, but still, whether they put it into this fund or whether they paid it directly to the plaintiffs, isn't there still a question as to whether the fringe benefits that were owed were paid?
I don't think there is a question of fact on that. I don't think they paid that. I think once you do the math, once they put that money back into the trust, just like at the beginning of the.
I guess maybe, the question we're asking is this. 4 of the 5 of us were on the prior case, okay? Those issues were before us. We made a decision back then. What changed from that decision that was narrowed in scope to this motion that our view changed, that there's not a question of fact? If I'm saying, it's not like you went back, you did another 10 depositions and all this discovery, and then certain things came out. It's basically the same proof before us today as we had, was it 18, 20, whatever year it was, 2018? Okay, that we had before us. How is it not how is it not our decision? It's still full force and effect as to question of fact.
Well, I think, I certainly respect that if that is the court's decision, that would go back to the trial court. I just would,
Look,
I would just
you're-
question what the jury would be asked.
Right, but look, your argument puzzles me, because his questions, all the questions favor you. You're trying to get this reversed, okay?
Right, I understand.
You keep arguing that there's no issues of fact. And there seems to be one huge issue of fact, and I'm the new guy on this, okay, so I'm just coming to this. But the huge issue of fact is, did the prevailing wage workers, did they get paid dollar for dollar what they were owed on the fringe benefits, supplemental benefits? Did they get paid dollar for dollar what they should have been paid? Your argument is, no, the employer put it into a pool that got distributed to everybody, prevailing wage and non-prevailing wage, so they weren't paid dollar for dollar. They disagree with that, but that's the huge factual issue. But you seem to be, would you agree with counsel that this is an appeal from a motion to re-argue?
Correct.
You didn't appeal from the underlying motion. So you can't get judgment. You're asking us, in the alternative, you want us to award you judgment and just send it back for damages, or even award you damages now. Would you agree that you can't get that from us? The best that you can get is reversal and send it to trial? Do you agree?
Well, I believe any time, upon the re-argument motion, you had, we were still back to their motion now for summary judgment.
Right, but you didn't re-argue your motion.
Correct, but I think under the case law, and I said it in my brief, I apologize, I don't have it right before me, but as long as there is a summary judgment decision made, the court can search the record, and it's the Dunham case, 89 New York 2nd.
Well, I keep looking at the Court of Appeals decision in Chesterfield from 2005, where the court says, in short, a contractor may provide supplements in any form or combination so long as the sum total is not less than the prevailing rate. I understood your contention is they did not get all the benefits they're entitled to.
Correct,
And
Your Honor.
therefore, we should reverse the trial court's position and send it back for trial like we did the last time.
Well, yes, except for, there's nothing left, I don't believe, for the jury to really.
Counsel, excuse me, you gotta, everything's being
Sure.
videoed and stuff
Yes.
and audio.
Yes, I do agree that on liability, certainly, that would be the case, and we could go back for damages. But I don't think damages, because they haven't offered a alternative damage argument. If we go back to the first summary judgment decision by Judge Murphy, that's what he said the expert proof came in. My expert proof can come in to show what valuation you put on these funds put into the trust.
Can I ask you this? I would agree with you that there's no issues of fact if, in fact, the defendant's theory of the law is correct. And their theory, as I understand it, is that Labor Law 220, this statute, the purpose isn't to benefit the employees. The purpose is to equalize the playing field between union contractors and non-union. So in other words, you don't want to give an advantage to people bidding on public works contractors that don't have to pay prevailing wages. He says the purpose is not to equalize wages amongst the workers. So here, what you're saying is the shortfall, there's a shortfall here. The money from the shortfall was put into a pool that goes to all the workers, including the CEO, who never spent probably a minute at the work site. The pool benefits the prevailing wage worker and the non-prevailing. You say that's not good enough. It should be paid directly to the union workers, or I'm sorry, not union workers, but the workers who worked on the public projects. But if his theory is right, then the defendant paid the same amount it was supposed to pay, it just paid it to the wrong people. There was a windfall here. By going to the pool, the workers who weren't working on the public works projects got a windfall, because they got prevailing wage and they were entitled to it. But again, his argument is the purpose of the statute is not to benefit the workers, is to equalize the playing field. And if he's right, then you lose, right? Then the pool theory is entirely appropriate.
But I think the purpose of the annualization regulation is to put a value on those funds that you put in that pooled trust. So when they put the money back in, if 50% of the people in the trust are still non-prevailing wage workers, they only get credit for 50%. And that's what the Department of Labor said in this case. That's what when they conceded to a willful violation, That was the exact issue before the Department of Labor back then. And they conceded, and they said they conceded in an agreement. It's not just a decision of an administrative department, it is a binding agreement that SUCO agreed to. They said they willfully violated the law and underpaid and conceded that they did so by following the same technique. And they could still, and there's three ways to follow the prevailing wage supplement. You can pay in cash, you can pay according to a collective bargaining agreement, or you can pay into a trust. If SUCO is allowed to do this, they can still undercut the collective bargaining agreements, because all they have to do is on the first go-around pay 10% of the funds to prevailing wage workers, put 90% of the trust funds in the CEO and everyone else's name. And then when you're short $9 million, you put the $9 million back in and you're done. And now it's cost you $2 million instead of 10. And that's the point. That's why.
I thought the position was, your contention is the individual workers are entitled to either the benefits or payment for the benefits, in that on their motion, they have not shown that they have been paid what they were contractually or statutorily entitled to.
That is my argument. But there are two basic arguments. One is, and I also believe when we get to damages, there's no issue of fact. And I think that realistically, I think that there's no position that they have taken that would establish a compliance with the law.
The issue is, you think the trial court got it wrong, the motion court, because the defendant didn't carry their burden to show that your workers got everything, which would be send it back for the trial.
Sure. First and foremost, they have to prove they paid all supplemental benefits owed.
Can I just, last question for me and then I'll be quiet. Sure. They rely heavily, and the trial judge relied heavily on the so order stipulation, where you allegedly narrowed the scope of your claims. Your claim initially seemed to be any shortfall had to be paid directly to the prevailing wage workers, the workers who were on these public projects. Your expert, Mr. Stanley, I think, he little unsure about that. So then they claim in the so order stipulation, you changed the theory. It's not anymore, you got to pay cash directly to the workers. It's you have to do the reannualization again. You have to keep doing that, because otherwise there's always going to be a shortfall to the worker. Is that correct? Is that your new theory? That you've abandoned, they say you abandoned the direct cash payment theory, and now you're on this, you have to do the annualization calculations again.
We did not abandon anything. I think the reality is, from day one, we've taken the position that we were not paid all supplemental benefits owed. And that's why, under the contracts, you're owed a certain amount. There's a credit that has to be determined according to the annualization formula. They're short. And that's the reason why they're short. And so it's not a change in position. It's that when they annualized, they could have and are incentivized to pay in cash, because it stops it.
It's a lot quicker. Otherwise,
Stops
you have to do the annualization
over and over.
a million times.
It'd be like cleaning a fishbowl tank, but only filling it halfway every time, and it's always dirty. And you never get it clean, because you never can clean the money. So that's the purpose. But they're incentivized to do that, but they didn't. So once they didn't do that, once they put it back in the trust, now they have to reannualize because they're short.
Thank you, Counsel.
Thank you.
Good morning, Counsel.
Good morning, Your Honor. Brian Butler for SUCO Corporation. With respect to the issue about the court's prior decision, the lower court specifically stated that the parties charted a new procedural course. And there was discovery conducted after this court's decision in 2018 as post-class certification discovery. There were interrogatories posed to.
But what difference is before? When I'm having a hard time struggling between the 18 decision, the 21 decision, and what changed after you narrowed the scope.
So Judge, we're not exactly sure, either from the lower court on the prior decision or from this court's decision, what the issues of fact were that were identified. But after that, the parties took it upon themselves.
Counsel, I understood you have Ms. Pittman, who is your payroll supervisor.
Correct.
She said she can certify that the individuals were paid the wage, but she cannot certify, and it took no interest in finding out if the individual workers who were accruing supplemental benefits under prevailing wage were ever paid. Does anybody say they got everything they were entitled to.
So Judge, the issue is not whether the workers were paid. It's whether Sioux Code provided prevailing supplements in accordance with the, the standards in that locality. And they can do that in a number of ways. One, they can
So you
provide
say
benefits
just
to an
by
ERISA
paying
plan.
the fund, they've satisfied their
that's-
obligations, even if the employees never get what they're entitled to under supplemental benefits.
The employees, there is absolutely no dispute, Your Honor, that every employee received fringe benefits through the ERISA plan.
Was it the fringe benefits that were commensurate with the fringe benefits paid to prevailing workers in that community?
Correct.
This dollar for dollar?
And Judge, nobody has done that analysis, and that's not an issue. The courts have actually said there is no requirement that there be this dollar for dollar, fringe benefit amount. So, for example, that I calculate that the health insurance provided through Excelis is worth X amount of money. What the law requires is that SUCO contribute the prevailing wage dollars into an ERISA plan. That's a clear choice that they can make that's provided under the law.
Putting into a pool, a plan, doesn't result in the employee being made whole dollar for dollar.
The employee is not, there's no obligation in the law at all for the employee to be made whole dollar for dollar. And that's what the action elector case really discussed, the Court of Appeals case.
Let's say I work for the Department of bidding on a public project, and I'm the only employee on the job site. I know it's not realistic, but I'm the only one. And I get paid no fringe benefits by my employer, who has a contract with the government.
Right.
And the prevailing situation in that community is that workers get health insurance and other fringe benefits. You're telling me that in that situation, the defendant can pay into a pool the amount, they have to figure out what the value of those fringe benefits is for me. They put that dollar amount into the pool. The pool includes not just me, but all the other people who are working on non-public work. They put that dollar amount, say $5,000 into the pool, and everybody's good, even though I don't get any of that $5,000. That's permissible.
That's correct. When you look at the regulation, when you look at the action elector case, Court of Appeals case, the law is clear that a contractor can deposit those funds, which are on a schedule. It's a schedule, prevailing supplement schedule, can deposit those funds into a trust, and that satisfies their obligation under the statute. The issue that...
Counsel, I don't understand how you believe it satisfies their obligation under the statute. Under Labor Law 220 sub 3, supplemental fringe benefits must be provided to such employees. The employees are the beneficiaries of the thing. Your attitude is once we pay it into the fund, whether the employee gets it or not isn't your obligation.
That's correct, Judge. The law, if you look at the action elector case, a Court of Appeals case, the court set the standard back then that those funds can be paid into a trust, they can be paid out in cash, or they can be paid in some other mechanism. The regulation at issue...
Is this because the purpose of the statute is to level the playing field with contractors, not to put money in the pocket of workers?
That's exactly right. In that action elector case, in that case, the Commissioner of the Department of Labor was trying to impose an obligation on a contractor to provide benefits to the employee. And instead, the contractor wanted to pay
But
cash.
counsel, that conflicts directly with the Court of Appeals in Chesterfield, which is 2005, that said contractors may provide or pay for supplements by furnishing their employees with benefits whose value match the relevant supplements, paying the supplements in cash or combining benefits and cash payment.
Right, exactly.
It's to the employees. It's
Well,
not to a plan
well,
or to a fund.
Oh, Judge, no, so the plan, first of all, the regulation at issue in this case, it's 220.2, 12 NYCR 220.2. That specifically says that a contractor can pay into a bona fide ERISA plan. And that's what
Provided the
that's what we
employee
did.
gets the benefits that they were
And-
entitled to.
and-
And that's what I don't see Ms. Pittman telling us. If you step forward with the proof that they had received every benefit they were entitled to, I'd say, okay, but it's your burden on your motion for summary judgment. And I don't think there's sufficient on this record for me or this court the last time to say that they received, the employees received the benefits. And you say doesn't matter as long as we paid it to a fund.
Judge, that's not what I'm saying at all. So, for example, if we paid this money to a fund and none of the employees received health insurance, life insurance, disability, vacation pay, et cetera, then I would agree with you 100%. In this case, it's undisputed that Suitco provided a full range
Right,
of
but
employee benefits to its employees.
What if those fringe benefits paid to the employees wasn't on the level of the fringe benefits paid to workers in that community, the prevailing wages? What if, because not all benefits are equal, right? I could have a health plan that's better than yours, or you could have dental. You seem to be saying the mere fact that the employees, the prevailing wage workers, get some fringe benefits, that's enough, even if those fringe benefits aren't commensurate with the fringe benefits in the community. Am I hearing you right?
Well, that's true, and because there's no way to measure that, and I know this issue was raised before the panel on the previous appeal, but ERISA would actually prohibit that type of analysis or inquiry into what an employer is providing in a plan. So what the Department of Labor has done and how the labor law is set up is that all it requires is for the monetary amount to be used for benefits. If it's not used for benefits, then it can be paid in cash. The contractor has the ability to do both. Looking into the specific benefits that employees are provided is frankly is preempted by ERISA. We don't get into that issue here because the contractor here did what it was supposed to do under the statute, deposit those funds into the trust.
Would you agree that under your theory of how it's done with the pool, there's a windfall for the non-prevailing wage workers for suit quote?
There wouldn't be a windfall, Judge, because it's clear also in this case that additional funds were deposited into this pooled trust, both through an annualization calculation and otherwise, that covers those employees. So there's not a windfall. In addition, Judge, this is a breach of contract case. The plaintiff's unjust enrichment case was dismissed, and that decision was not appealed. There's a breach of contract case, so we have to point to a contractual provision that required Suitco to do something other than it did. And there's not, as the lower court said, there's nothing in the statute or regulation, certainly not in a contract, that would provide that Suitco needed to do anything in addition to what it did to provide its employees with benefits.
Under his theory, am I correct, that if it has to be directly into the pockets of the prevailing wage workers as opposed to the pool? If his theory is correct, what would happen in your view is that the defendant would be double paying. Because the defendant paid into the pool, and if we say that's not good enough, then he's got to pay again directly to the workers, and there's a double payment, right?
I think that would essentially be correct, but that's definitely not how the statute is intended to work. There's no requirement to pay in cash. There's no requirement to reannualize. There's no requirement that a contractor have to choose one over another. If they put it into a trust, they've satisfied their obligation under the statute.
Mr. Stanley said, his deposition, he admitted he didn't know if it had to go directly cash. When he was asked, is there any law or regulation, he says, I don't know. But then he comes back after a break, he talked to Mr. Finn, he comes back and says, I want to clarify, you don't have to pay in cash, but if you can do it individually, it has to be into a trust individually for that employee. That's different than the pool. So we have an expert. Is there an issue of fact there on his testimony? Even if we put aside his affidavit, he says it's got to be a trust individual to the employee.
No, there's nothing in this. So we're dealing with a breach of contract case. So we look at the prevailing wage, or we look at the public works contracts at issue in the case. Then we look at 223 of the labor law, and we look at the regulation. There is absolutely nothing anywhere in any regulation, in any law that says we have to put money into a specific trust for an employee. If the legislature wanted contractors to do that, they would write that into the law. Frankly, if the DOL wanted contractors to do that, they would implement a regulation providing for that. There's nothing at all that requires that. And so that testimony is completely unsupported, Your Honor.
Okay, I think we have the argument. Thank you. $455 Abdelhay v. 1105 Group Property Management LLC. Good morning,
Good
Counsel.
morning, Your Honor. Mark Goldberg, Phillips Lytle, on behalf of the plaintiff appellant respondents. If it may please this court, this is a very simple matter, Your Honors. This is a labor law 240 case. As Your Honors well know, and as the Court of Appeals has stated repeatedly, the labor law imposes an absolute liability on owners who fail to provide or erect safety equipment to give proper protection. This record is undisputed. At the time of the accident, Fazi Abdelhay was using a 12-foot step ladder that had been provided to him by his employer, Nabali Electric.
It's pretty clear the ladder was too short for the job.
Absolutely, Your Honor, right on point. And the defendants provided no additional equipment. In fact, the defendant's own representative, Shaibi, testified that they relied upon the contractors, in this case Nabali, to provide the equipment. So there's no dispute.
Well, so there is proof in the record that there was this taller extension ladder, at least perhaps being used by the contractor, as you say.
So-
I forget the name, Naboli, right?
Nabali, yes, Your Honor.
So, and the defendant, of course, says that ladder was available, and the plaintiff was using a 12-foot ladder, and that was inadequate for the job, and the plaintiff should have known that. You say, at a minimum, there's a question as to whether that taller extension ladder was even available.
I say there's a question, but I actually think it goes further factually, Your Honor.
You say it's not available.
I say it's not available, okay? Jamal, who is the plaintiff's brother, who was working 50 feet away at the time, was asked questions, but not asked the right question. He was asked specific questions about, was there a 22 or 24-foot ladder on the property? He said yes. And then he specifically asked the question, was it on the job that day? And he says, I don't know.
But he said, and his father said, I believe, that it was on the van and they took it every day.
Right, but on the
they had-
particular day, Your Honor, when they were asked, is it on the job, and I can actually cite the specific section of the record that said that, his response was, I don't know. And the case law makes it very clear. The key is it's a four-part test. And that's what they missed, the 4 prongs. That the plaintiff knew that there was an adequate ladder. That day, which is, I argue there's a question, because Jamil says, I don't know where it was on the job. And the case law says that the mere presence of a ladder on the site, although it might have been there prior days, nobody has testified that it was specifically there that day and that morning and available that morning. There was no questions ever asked of the plaintiff. Was it your normal practice to go get a ladder? He indicated he didn't remember. He had a head injury and he didn't remember. They try to make an argument about the fact that the plaintiff shouldn't be allowed to hide when he has his own knowledge. But they bear the burden of proof. They could have asked other questions. They could have asked, was it the normal practice? Did other people use it? Did you regularly use it at that location? The record's void. So they rely upon 2 people, the father and the brother, to provide testimony that some ladder that was supposedly on the job, that supposedly was on a truck, may have been available.
So you're right, they bear the burden on their motion. You, of course, cross-move, or you also made a motion for summary judgment on 240. So you've got the obligation then to establish, as a matter of law, that this ladder was not available to the plaintiff.
Or that it was not adequate.
Or that it was not adequate.
And it's a 4-part test, and I think that's the part. It's not in the alternative, it's in the conjunctive, okay? That the plaintiff knew that the alternative ladder was present. I submit, Your Honor, based on his direct testimony, the plaintiff testified, he did not know. The record is undisputed. Argument number 2, and very important.
The record is undisputed that the plaintiff
That
did
the
not
plaintiff
know?
testified he did not know. 2,
Not that the letter was unavailable,
Right.
just that he didn't know it was unavailable.
he didn't know it was, he was asked specifically, are you aware that there were extension ladders? He said, I don't know. And I can direct Your Honor to the specific
No,
section.
I'm not concerned. The question is, did you bear a burden by showing it wasn't there? in order to win on your
I would argue we did, Your Honor, because of the four-part test. First, they asked the plaintiff, did you know it was there? He said he did not. Part two, that it was an adequate ladder. There is testimony in this record, based upon the expert's testimony, the expert's affidavit, Mr. Caniglio and Mr. Kiska, that 24-foot extension ladder was not an adequate ladder. That extension,
because the way the shelves hung out, and the way it would have to be positioned.
and there was debris on the floor, and there were boxes, and there's testimony to indicate.
But there's also testimony he was able to use enough room on the floor to use an A-frame ladder, too.
But the 8-frame ladder was below the shelving area, and that's another reason why I couldn't reach. The 24 ladder would have
I
needed.
saw the photos, they're recognizable.
It would have leaned at a certain
We
angle.
can take notice of the ladder that's there and the width that it takes up on the floor. So I don't think that's your strongest argument, the fact that.
Counselor, I agree with you, they didn't meet their burden to get summary judgment. I don't see how you think you met yours.
Because, Your Honor, as a practical matter, Mr. Abdelhay, it's a four-part test. Mr. Abdelhay needed to know the ladder was available. I argue he didn't know. Two, that it was an adequate ladder. Based on the testimony of the affidavit of Caniglio, Caniglio says unequivocally it was not an appropriate ladder.
But their expert doesn't agree with that. Isn't that a factual question?
Well, so now the third part is that for no good cause, the plaintiff chose not to use it. There's good cause. The fact that there's a dispute in the record as to whether or not that ladder is adequate doesn't impose a duty upon Mr. Abdelhay.
What's the cause? What's the cause? Because there was debris on the floor?
There's debris on the floor.
Did you just move debris to the side?
Well,
I mean, how is that an excuse not to use an appropriate safety device? If there's boxes on the floor, okay, just move them 2 feet to the right.
Debris on the floor. First of all, he didn't know a ladder was there, so he didn't know
No,
that he used it.
he says he doesn't know.
Okay. They bear the burden to prove it. He didn't.
We're on your burden right now. We're on your
Fair enough.
burden.
So the ladder for no good cause, the shelving created an impediment. And three, more importantly, while using that ladder, required it to be at a particular angle. The father and the expert both testified that the ladder at that angle caused a danger because of its movement while he's pulling conduit and wire. There was good cause to believe that that ladder was not appropriate.
Your expert's theory seems to be there was no safe way to do it while the shelving was up. Had to take the shelving down. Do I read his affidavit?
I think that's correct, Your Honor. In
Yeah,
fact, Shaibi, who is their representative, made it very clear that only a ladder could have been used. And they actually argue that our client should have removed the shelving, or as Your Honor says, remove the debris, which I submit they don't have to do that. I think
Push it to the side.
I would argue that they have to provide an adequate safety device. That's what the whole purpose of the labor law is, and that actually didn't happen here. So you're requiring him to redo the room, move garbage, take down the shelving, make a determination whether or not the angle was appropriate, which is exactly in contravention, is putting a very big onus upon a worker and in contravention to the labor law. I'd like to reserve to obviously address any issues on this file.
We don't allow rebuttal in the Fourth Department.
Then I just want to address the one issue. There is an argument raised in their reply brief with regard to the sufficiency of the affidavit of Mr. Caniglio. They make an argument that it's speculative. While it was not part of our brief, it was briefed in the court below. I submit to your honors that it's really not an issue. Our expert relied upon the same exact measurements, the same exact photographs. And there's ample case law, if your honors would request, I'd be more than happy to provide. I don't really
Do you
think.
want to address their argument about sole proximate cause?
Certainly. So the sole proximate cause issue is very clear. First of all, if there's a violation of the statute, the sole proximate cause is not applicable. Their failure to have provided an adequate safety device in and of itself precludes their reliance. And the issue then is secondarily, which we've discussed a moment ago, is the alternative ladder, which I believe is a matter of fact in its application to the law is inapplicable.
Thank you.
Thank you, Your Honor.
Morning, Counsel.
Good morning, may it please the court. Kevin Krupa for Respondent Appellants, 1105 Group Property Management. What I'd like to touch on is the fact, and the court noted, that there is ample testimony that this 24-foot extension ladder was on the job site. Both the brother who was working with the plaintiff on a daily
Yeah,
basis.
but without having it or seeing it, how do we know if it was adequate in a sense of rubber feet, whether it meets the code and other aspects? How do we have that in order for us to establish, to meet your burden, that that wasn't sufficient?
Well, Judge, with respect to my burden, I would say that maybe there is a question of fact on this case. But I think there is a question that whether or not that 24-foot extension ladder
So
was
your
on the job.
position is plaintiff certainly isn't entitled to a summary judgment, and you don't necessarily agree that you are.
I certainly agree that plaintiff is not entitled to summary judgment, and I think maybe I'm
It's a
entitled to
question
summary.
of fact as to whether you are, which means you don't.
Correct, Your Honor.
Okay.
But I do think that there is ample testimony that that ladder was there, it was an alternative safety device. Our expert went and used an extension ladder at the site, which their expert did not do, and he proved that that could be used to reach the conduit
He
When the
says-
shelving's
says-
up.
yeah.
when the shelving's up, correct?
Well, he seems to be of the position that because the plaintiff says, I don't remember, I don't know if there was an extension ladder there, that this 24-foot extension ladder, that meets his burden of proving as a matter of law.
I don't think it does, Your Honor, because, and I think the trial court hit the nail on the head during oral argument when it said, the question is not what Mr. Appellate remembers now, it's the question of what he knew then. He's the foreman on the job, he sets up the job, he gives out the instructions, that ladder's on his van, there's another same ladder on his brother's van, it was there that day, his brother confirmed that, so did his father.
They changed their story when they put in affidavit that seemed to be not entirely congruent with their deposition testimony.
Correct, Your Honor, and this issue of they're not being asked the right questions, plaintiff's counsel had the opportunity to ask questions too, those questions weren't in the deposition. So then they came back and they have affidavits trying to evade or avoid that prior testimony. And I cited a case in my papers, I believe it was in the first or third department, that says that if there's a relationship between the plaintiff and a non-party witness, that's a credibility issue. So certainly you have the father and brother who they may say anything to help the plaintiff out with this case. It's their job, their equipment, and there's certainly a question of whether that 24-foot extension ladder could have been used that day, and it was there that day, based on their deposition testimony.
Okay, thank you.
Thank you, Your Honor.
456, Fragola v. Getnick, Livingston, and Atkinson. Good morning, sir.
Good morning. Good morning. Thank you for allowing me to be here today. The only question before this court is, are two first choice realty deeds prepared by the Getnick, Livingston, Atkinson, Gelati, and Pereira law firm?
I'm not sure that's the first question. The first question is, I thought, is you weren't allowed to bring any further litigation without permission of the court, and you didn't get permission to bring this litigation. I'm not sure, since you didn't have permission to bring the litigation below, you have the right to be here in front of us.
Well, Your Honor, if you look at that issue, if you have it before you, you're going to see that was for a Playtime Boutique, Inc. issue. And if you look at it closely, there were two issues there. And the judge said he was making that based on one of them. And he didn't make any decision on the second issue in that court. This is an issue of first choice realty. I am the president, shareholder, and I'm under an obligation to wind up the business affairs of First Choice Realty by the New York State Legislature. And I'm here on the benefit of the New York State Legislature to wind up those business affairs.
Right, counsel, or not counsel, but sir, your arguments are set forth very well in your brief. And we've read the briefs, and you did a really nice job laying it all out there.
Thank you, Your Honor.
So I think speaking for me personally, I understand what you're arguing here, so thank you.
Thank you.
See, sir, what it really boils down to is we have to look at whether or not the court properly dismissed the complaint sui sponte. Because we agree with you, this was one motion to vacate, and not a motion to re-argue. So
Yes.
we'll take a look at whether or not the court abused its discretion by sui sponte granting its own motion to dismiss the complaint without any hearing whatsoever.
Yes, Your Honor.
Okay, we'll look at that issue.
Yes, that's basically it.
Okay.
I have a case here, then I'll get out of your way.
Okay,
That kind of sums up everything here. And it's an issue here that unless this decision by this court is reversed, what's going to happen here is that people owning property, they can lose their property without having due process. Some moron can come in and take their property, and these criminal forgeries, they'll be able to do so, according to this case, because there is no motion to get into it. It's all started out as a...
yeah, well, Counselor, sir, excuse me, we recognize it. Really what it boils down to, it boils down to whether or not the prior decisions regarding what happened, and that is really the law of the case, so to speak.
Yes.
So, and if it's not, and it is separated, it's something we look at, or has this been something that's been previously decided, and so to speak, that ship has sailed?
But, Your Honor, I would just like to say that if the deeds are...
Yeah, but Counselor, before I go, you handle yourself well enough, that's why. We have to see whether or not the underlying order in which the court relied upon is applicable here. If that's the case, that's the
Okay.
law of the case, and we can't reach it. We have to look at the fundamental operation of what took place. If those are the same orders that you've been precluded from doing any action without prior permission of the court, then the court was well within its discretion. That's the finite point that we have to look at.
But as I said...
We get it.
As I said, I just stated that that's on a different issue.
Yes, and that's
on
what we have to take a look. If it's a different
Time
issue,
issue.
then we recognize the court obviously didn't follow it.
And I believe you might find that on our
I think it's in your brief.
Yep.
Yeah, so we
Yeah.
got that. We're set with that. We got it.
Yeah, you'd find that on and it's going to say Playtime Boutique.
Yep.
And that's what it's all about. I mean, we're here to wind up the business affairs of First Choice Realty on forgery deeds.
We have it.
But I think this one case kind of sums everything up in Caricati versus Caricati, where that court said, under state law and general contract law, a forged signature or deed renders a contract void ab initio, because there can be no meeting of the minds of the parties when a forgery has been perpetrated.
Sir, we're familiar with that. It's sound case law. It's sound law. We're familiar with that law. The question becomes is whether or not was this issue previously litigated. If it wasn't,
Yes.
that's applicable. We'll take a look at it.
Okay. Okay, thank you.
Thank you very much. $457 Gay v. Gay. Good morning.
Good morning. May it please the court, my name is Lisa Cuomo, and I appear on behalf of Timothy Gay. More specifically, we're here to discuss more qualified domestic relations order, which was ordered by the Supreme Court to be prepared using the Majuscus formula.
You say, so this really comes down to the stipulation.
Correct.
The on-the-record stipulation, and you say that the stipulation clearly included nothing more than the plaintiff's police service credit. There was no mention of any additional service credits, these service credits that were purchased. And if those were intended to be included, they should have said something during the stipulation.
Exactly. That's the whole thing.
You're not arguing that it couldn't be marital property.
Right.
That's
I'm-
not the issue here. That would be an interesting issue, because part of the military service, like a fifth of it, was during the marriage, and he did use marital funds to buy back those years. But we're not talking about what a court could have done. We're talking about what did the parties intend, what did they agree to?
Exactly, what was
And
contained within the stipulation.
Maybe she could have gotten 289 numerator.
Correct. However, it was
But-
never discussed in the
And- and-
stipulation.
She took 253, and she stuck with 253.
And the only way we get around that is if obviously there's any ambiguity to what was put on the record from Mr. Babineau and Mr.
Correct.
Baldwin. And if there's no ambiguities, they're bound by the stipulation. And that's
Exactly.
probably the contract of principles. It's in all four corners.
Yeah,
I think we have your argument.
okay, all right, thank you.
Thank you, Counsel.
It was nice to see you.
Good seeing you. Good morning, Counsel.
Good morning, Your Honor.
4:59, you came right up on call, and it's, what's it, Mark M.?
Yes,
Okay, and the appellant has submitted, is that correct?
that's correct, Your Honor. I only learned that opposing counsel was submitting late yesterday afternoon when I was already en route to Rochester. I do have a brief argument for respondent if the court feels argument would be helpful.
Well, you're asking us to affirm, correct?
Correct.
I guess the question to be asked is, do we have any questions? Do we have any questions?
I don't have any.
All right, well, then we will rest on the briefs. Thank you.
Thank you.
Good morning, Your Honor.
Morning, Counselor.
Be back after a few years.
No comment. Just go right ahead.
May it please the court, I represent R.A.G. Herkimer. This is a condemnation case that we tried on the issue of value. I'd like to first start just with the whole issue of valuation and sales comparables. The issue is, in these types of cases, is whether we're comparing apples to apples so that we can figure out exactly what the valuation is. We relied on we categorized the property as a large, shovel-ready, commercially zoned property with sewer and water.
When you say "we," you're talking about your expert primarily, right?
Our case and our
Because
expert.
the two experts came to different opinions. Your expert said that the highest and best use was general commercial, and the county's expert came to the conclusion that the highest and best use was low-intensity commercial use. And the question for us is whether the court's decision to accept the county's expert's opinion is based on a fair interpretation of the evidence, right?
A little more twists and turns, but I think that's the general heading. I think you start with first their expert, and I know we're not exactly challenging his credibility, although I find him to be incredible, but there was questioning by me about apples to apples and whether or not if there were no recent comparable sales of shovel-ready commercially zoned sites with water and sewer in this community, you have to either expand the territory or go back in time. He says, yes. That was him on cross-examination, and this is page 397 and 98. He conceded that you had to expand the territory in his testimony. Now, he employs a method, and he conceded that there were no such sales in that county or any of the surrounding counties surrounding Herkimer County. He employed.
But I suppose it's dependent, how do you expand the territory? Because the court concluded that your experts' comparables were from, I think the language was strikingly different markets.
Okay, so let me start first with what the court talked about in terms of this large shovel-ready. Basically, what the court said was, I think, although it wasn't explicit, that our theory of the case wasn't feasible, that you couldn't have, for example, multiple housing units and all the rest, that they were, quote, more intense uses. But if you look at Mr. Hatzinger's comparables, and the prime one that he used, number 3, was a large apartment complex. Exactly, 4 of ours were large housing projects. His main one, which was not an arm's length sale, was a housing complex. So when the court says low intensity, high intensity and whatnot, I think you have to look at the background of how that got into this case. When in 2008, when these cases were, or this property was first appraised, and these appraisals are in the record, although we didn't rely on them. One of the things that was going on was big box sales. Home Depot and Lowe's were coming to town. And the big issue having to do with that was traffic counts, because traffic counts would allow you to have a commercial use. And that's when their experts started talking about high intensity and low intensity. We did not rely upon any commercial use here. We relied primarily on 4 housing projects, a truck terminal, and some medical centers. That was basically it. Now, are those high intensity or low intensity? In our perspective, it doesn't really matter. I mean, you have to look at general commercial use and whether that's proper.
Really, I guess asked earlier by my colleague, and which is interesting, and I hear what you're saying, but this really boils down to, we did the methodology that's being used by the experts. And what is the basis of their methodology? You know, like you're saying, low intensity versus high intensity, evaluation-wise, and really what we're stuck with to a certain extent is the 4 corners of the record. And as you pointed out to us, you know, some of the testimony that you feel was given by the county's expert was obviously favorable to your client, but the court appeared to have geared this a different way, at least that I can gather here.
I agree.
And because I have to tell you, what caught me, and it's not that it's going to drive it, is that, you know, and part of your argument is that, you know, really, what should the floor have been? Should the floor have been really, what does he have invested into this thing? That really should have been the floor and not even beyond the ceiling. And it doesn't seem to make sense in some aspects or respects here that your client's got X amount of dollars invested into this piece of property, and at the end of the day, it's valued at less. So there should have been a floor to begin with, and the county's expert was nowhere near it.
So let me go on to that issue. They call it condemnation blight. I call it manifesting adjustment. It's a rule of evidence. It's not a rule of law. In these valuation cases, it allows you to look at broader circumstances to see whether or not what's happening just isn't fair.
But when we turn to comparables, and I says, as Justice Pirallo pointed out, and there's some comparables, whether they're near bigger cities, up north, closer to Syracuse, as opposed to rural communities like Herkimer, which I'm familiar with Herkimer because it's within the 5th District, you know, and that's where I have to tell you, I do find some of it troubling, only because of the fact that.
Well, let me tell you what I am most troubled with. I think every one of their comparables in their appraiser's report is deeply flawed. Number 1, okay, so you talk about low intensity, high intensity. Number 1 is a greenhouse, zoned residential with no sewer and no adjustments, and the court adopts that. I submit to you that as a matter of law, that is absolutely ridiculous to compare that to a large commercial site with water and sewer. It shouldn't be done. And I cross-examined their expert about it, and I said, this is more comparable to agricultural, right, with low values? And he said, yes. but the court relies on it. I mean, to me, it's a no-brainer. And I realize this is expert testimony in some respects, but really what it is a person reporting facts that you can verify by looking at the record. So in terms of the expert having special knowledge or anything like that, these are facts documented that you have just as much right to review as anybody else, because it's not particularly within that expert's knowledge. The second one, which the court relied upon, was a car dealership in which, with 3-4 acres, where the expert put most of the value on the building. And there's no way you can extract land value from that sale. It just makes no sense. The court recognized that, but said, well, we're going to rely upon that a little bit. The third one is not an arm's length transaction, and this is a similar type sale. I'll give you that. It's residential, or it's for residential purposes. It's zoned differently. It has water and sewer, but on the state website and on the town's website, it's not an arm's length transaction. He was asked, did you verify this? Yes, with the zoning officer. He didn't know this was coming, that it wasn't, that it was listed as a non-arm's length transaction. When I confronted him with it, he fumbled around. Then he ultimately said, I valued it, or I confirmed it with the developer. What does that mean? I mean, that it was they lied on the transcripts? I mean, this is documentary evidence that you have the right to rely upon, and should. The fourth comparable was a small sale, 3-point-some acres, but it was a wedge-shaped lot, of which the first third you couldn't use because of its shape. So it's really 2 acres. And the court found that to be of some value, but discounted it 40%. When you get up into the 40% of adjustments, just because of location or whatever, we submit to you, it makes no sense. So we have basically no similar sales in the area, and 4 very clunky comparables that the court relied upon. Add to that the manifest injustice, which is the fact that they took this, or they voted to take this property in 2011, at which time we had over $1 million invested in it. We had all kinds of offers before then. When they vote to take it and they appropriate the money, the offers stop, uncontradicted by the broker, by Jim Wallace.
Were some of the offers turned down by your client? Do I remember
Yes,
that
some were
correctly?
options, but the point is not the specific dollar value and not the specific deal, but there was a lot of activity. And then 2011, they vote to take it and they appropriate the money, everything stops.
And the price that was paid to the government, it was far less than your client paid for it in an arm's length transaction. Am I right on that?
Right, so my point.
Your client paid for, was it 800 some odd thousand?
Yeah.
And then that was before remediation, before doing all these things that enhanced the value to get it up
Right.
here, and then they get down here. And
10 years later.
And what's changed in that situation? Your clients took a bath on this, massive bath.
We took an absolute bath, and that's why I submit to you this whole issue of manifest injustice. It's not a rule of law. I mean, you don't have to rely on it, but it's a rule of evidence, and it's a check. I try a lot of property damage cases. I always have, in various insurance contexts and whatnot. And valuation, in a lot of respects, is opinion. You can look at comparable sales. But the other data, in this case, his investment, what you pay for a property is always prima facie proof of value. What you invest in a property, undisputed, is proof of value. And when you check what the court did and what their offer is against what my client had invested in this case, I mean, it's not even close. We're getting basically 30% of what he had invested in the
I mean,
property.
they would say, well, your client just made a really bad investment. Just because you buy stock at a certain level doesn't mean you'll be able to sell it for that amount. But
Well,
what changed, I guess your point is, they paid 800 something, they cleaned it up for a couple $100,000 more. What has caused it to go down? That's assuming that it was an arm's length transaction with your client back in the day.
Well-
It doesn't really make sense. I agree with you. It doesn't seem to make sense
And-
that the market value would drop so precipitously after all these improvements.
and couple that with 4 very clunky comparables on the part of their appraiser. I mean, they're just not, they're not apples to apples. They're apples to something else, and trying to extract things out. And okay, you reject all ours because they're not within, 10, 15, 20 miles. But what else are we supposed to do? Herkimer is a small population. It's a hilly county. There's not a lot going on. The one thing in our favor is near the thruway, which all these other ones that my client's expert relied upon, near a highway, 2-3 miles off a highway. He's trying to get something comparable. Sometimes you can't get something identical or even close to identical. The lower court never said that my client's expert was not to be believed or not trustworthy or anything like that. He just didn't like the comparables, and we didn't like them either. But what happened here doesn't satisfy the constitutional requirement of fair compensation in an eminent domain case. So that's our case. Thank you.
Good morning, Counsel.
Good morning, Your Honors. May it please the Court, I'm Chris Russ from the West Law Firm for Respondent, Herkimer County. The lower courts, the context which the lower court had in this case is also important for this court here today, as this was involved Herkimer County's taking of 3 parcels of land from the claimants, only one, Lot 6, which was suitable for any kind of commercial or residential development, to build and operate a new county jail. The site last had a PNC grocery store tenant, which failed in 2004. There was no commercial, residential, or other interest in the property after 2004. The site had been marketed for years since the PNC departure, but it's in a remote area on Route 28, a mile away from the high-intensity commercial area on Route 5, where the commercial developers and businesses would rather operate. There was discussion of Home Depot and Lowe's were coming, and that's where they wanted to be, on Route 5, not a mile away on Route 28. Now, the claimant had purchased the site in 2007 from a predecessor company, and both of the companies were owned by various parties of the same family, the Grossman family. And the sale was a means of preventing a bank foreclosure sale on the site. The claimant demolished the existing building in 2007. In 2009, the county's interest was piqued and chose the site for the new county jail. After prolonged unrelated litigation with the village of Herkimer, which held up the taking and conveyance, the county finally proceeded and took the property in 2018. Prior to the taking, the claimant incurred the cost of remediating the property due to a petroleum spill from a long-gone service station that had once operated on the property. For this litigation, the parties had agreed to value the property as vacant land using comparable sales to determine the fair market value as the highest and best use for the site. With regards to the claimant's remediation, the county and its appraiser did not take any deductions for the contamination or contamination stigma relating to same, which actually benefited the claimants in the valuation, as claimant had voluntarily undertaken the remediation. As you know, the county's appraiser was Mr. Hatzinger, whom the county had used for many years and who was intimately familiar with the Herkimer County and Mohawk Valley markets for well over 50 years. Mr. Hatzinger identified sales of 4 properties in the Mohawk Valley, all within 30 miles of the site, as comparable to Lot 6, and 3 properties comparable to Lots 5 and 11, which were undevelopable or conservation lots. These comparables are significant because although they were not all located in Herkimer County, they were all in the Mohawk Valley area, which shares similar economic and demographic markets, which can be described as less than vibrant. Hatzinger's comparables were by no means identical to the site, but he made appropriate adjustments.
Counsel, I'm
Yes.
still struggling with the fact that when they purchased it in March of 2007, what did they pay for?
My understanding from the record, it was over 700,000,
I
but
thought
that,
it was 843 plus 33,000 in taxes. And now somehow, between 2007 and when the county valued this property and condemned it, it dropped to 500,000.
as mentioned, Your Honor, the sale in 2007 was between entities owned by the same Grossman family. The property was in risk of
So you're saying that
foreclosure.
isn't a fair basis of evaluation, so we shouldn't start with the idea that it was 843 and the county's offering 500 and something.
Well, the lower court, Judge Merrill, found that this was characterized this as a stress sale in that, there was not a lot of inquiry into the sale as to whether there was one mortgage, multiple mortgages, what exactly comprised the amount that needed to get the property out of foreclosure. That would have been a trial within a trial, which I don't think was relevant and necessary for the eminent domain proceeding in this case. Mr. Hatzinger in his appraisal made no downward adjustments for the existing concrete foundation, slabs, and the paving which would needed to be removed from the site in order to build the new jail. Let's see. He also accounted for the fact that the neighborhood had experienced no new development in the past 20 years, and prior to the P&C Market's occupation of the property, several other retailers had failed while located at the site. Mr. Hatzinger's ultimate finding was that the highest and best use of the property for purposes of valuation as to what was economically feasible, maximally profitable, and reasonably likely to occur in the near future was the low-intensity commercial use, such as small offices, a garden center, or nursery. Claimants chose their appraiser, Kevin Bruckner, who, although he was a qualified and experienced appraiser, had little to no knowledge of the Herkimer and Mohawk Valley areas. He immediately expanded his focus for comparable sales to remote areas such as Schenectady and Saratoga County, 50-plus miles from the site, and some as far as 200 miles away in Monroe and Clinton counties.
Well, Counselor, I see, a lot of this is obviously in your brief. I mean,
Oh, yes.
Yeah, I mean, in your reading from, we've read your brief. I mean, our concern here is this, the court is looking at the experts and whether or not the examination direct and cross and the exhibits put in, whether or not established, whether or not the court concluded correctly. And obviously, one of the issues here is what's the, this high intensity, low intensity versus the location of where Mr. Longstreet's client or the expert obtained this information. And what, I mean, what I have to be honest with you, what's striking to me is the fact of the cost of what the individual is into this piece of property, and the court seemed to have bought or believe your expert to a dollar. There doesn't appear to be, sometimes we get them in there, well, let's see, we got a low, we got a high, and the court comes back and says, okay, we're at 1.6, you're at 500, the court agrees at 800 or 900. It appears the court discounted all of the appellant's expert here and went with your expert.
Yeah, sure. But within the context of a full 3-day bench trial, Judge Merrill heard all of the evidence. Both of the appraisers presented their written appraisals and their rebuttals to the other. They were both gave testimony and were cross-examined. Ultimately, the most important issue for the lower court, Judge Merrill, was the credibility of the parties' dueling appraisers and the quality of each other's work with regard to their calculations of comparable sales presented and as applies to the site in this case. After the trial, Judge Merrill issued a thorough 40-page decision deciding the outcome of this action, which admittedly this is not the most glamorous legal subject for 40 pages.
What's our standard of review of that?
The standard of review for this court, obviously you have a broad de novo review. The standard was set forth in the City of Syracuse Industrial Development Alterm Inc. Case. This is 20 AD 3rd 168. And this court held, upon such a review, the record should be viewed in the light most favorable to sustain the judgment. And this court should evaluate the weight of the evidence presented and grant judgment warranted by the record, giving due deference to the trial court's determinations regarding witness credibility, so long as those findings could have been reached upon a fair interpretation of the evidence. The county urges that this court should heartily and completely affirm Judge Merrill's decision. In short, he found the county's appraiser, Mr. Hatzinger, was more credible and adopted, for the most part, his comparable sales as appropriate, relevant, and reflective of the site's market, and agreed that the low-intensity commercial was the best and highest use. His crucial determination in rejecting the claimant's appraisers' comparables was stated as follows: the court has weighed the evidence and finds that Mr. Bruckner's sales are not sufficiently comparable so as to serve as a credible guide to the fair and realistic market value of the subject property. The primary problem with Mr. Bruckner's appraisal is that he utilized sales in geographically remote areas and higher intensity commercial markets chosen primarily due to their larger size, without any market analysis or evaluation of the sites involved in his comparable sales. More importantly, his appraisal intentionally makes no adjustment for what he acknowledged to be the better economic base in those locations.
Counsel, not to cut you off, you believe Judge Merrill took all these factors into account in his 40-page decision, and that we should affirm him.
Absolutely, and furthermore, there should not be any doubt about the fairness which he approached and evaluated the evidence in this proceeding and at trial. For the valuation of the conservation lots 5 and 11, Judge Merrill said he found both appraisers and appraisals to be helpful and useful for determining the value to be ascribed for these conservation lots. For value in Lot 6, he actually rejected Mr. Hatzinger's
We've read his
comparable sales.
decision, Counselor.
Okay. No, so he gave and took on both sides. He didn't completely take the county's appraisers, Mr. Hatzinger's appraisal, and he didn't completely reject the criticisms that Mr. Bruckner had of that appraisal. You know,
He accepted those parts of the opinions that he thought were appropriate to accept.
Yes, absolutely. He also found that, he noted in particular, that Mr. Hatzinger's extensive experience in the Mohawk Valley real estate market firmly lent his opinion and added level of credibility to his appraisal and his opinions. You know, county posits that...
Counselor, not to interrupt you, and I don't mean to be rude about it, but I'd rather you talk to us than read to us. You spent the last 10 minutes reading to us. The questions are being asked to try to elicit what's information we want. You have a record. You have a brief. You've submitted a brief. We've read the brief. You heard the opportunity to make an argument to us. We don't need it regurgitated. And so the questions are specifically asked by my colleagues.
Certainly, Your Honor. Basically, we stand firm by Judge Merrill's thorough and thorough decision that in findings of credibility of the witnesses, the appraisers being the most important witnesses in this case, and that the standard for review has been met, that it should be weighed in favor of sustaining the judgment of the lower court.
Thank you, Counsel.
Any other questions? Thank you, Your Honor.
Thanks. Mike.
Nice to meet you. I'm Chris.